on this presidential jet seizure, reactions to it, where the loopholes are, where the fault lines are. And joining us for that conversation right now is former presidential aide, Mr. Akande, host of Inside Sources. Nice to have you on the program, sir.
Thank you. Good to see you again, Keller.
Let's take a look at the timeline, first of all, of this presidential jet seizure, because it came on, we saw it on social media, and everybody was, what happened, and then we start to hear all of the stories. So let's see if we can get through all of the things that have happened from the beginning. We've gone through this before, but we do have to go through it again, see how it all started. But while we're getting that together, in 2001, China and Nigeria signed a bilateral investment treaty to encourage investment between two countries. Nothing wrong with that.
Yeah.
Then they now moved on to the next phase, which was in 2010. Zongshan, you have to forgive us if we don't pronounce it properly, Zongshan Fucheng Industrial Investments, through his patent company, acquired, to develop the Ogun, free trade zone, right? The Guangdong Free Trade Zone in Ogun State. Not bad. Not bad. In 2011, they set up a local entity, that was supposed to help them with international investment. This was in 2011. At this point, I'm going to ask you, were you aware of this at this point, though?
At 2011?
2011.
No, we weren't in government until 2015.
Okay. Until 2015, you were in government.
Yeah.
Zongshan set up a local entity, that's Zongfu International Investment, to manage the development of the free trade zone. The Chinese firm then carried out several works, including development of infrastructure like roads, sewage, and power works within the zone. At this point, was the federal government supposed to be, in your view, Laulu, was the federal government supposed to be a part of this at this point? Well,
so what happened is that everything is based on the bilateral investment treaty, which the federal government signed with China. Okay, so that's actually the, like they will say outside, the cocoa of the matter, is the bilateral investment treaty. And what that has done, based on what the experts have explained to us clearly, is that there's a clause in that treaty that allows citizens of either country to bring up an action. Normally, what you will have is that, look, this is the treaty between Nigeria and China. And so if there's going to be any action, court cases, adjudication, litigation, it will be between China and Nigeria. But what seems to happen is that somebody permitted a clause, and one of the articles of that treaty, to say that citizens or businesses of either countries can bring a charge. That is the unusual thing that happened in that treaty that has now given rise to a situation that we are dealing with today. So
people saying that the courts in France, and most people don't realize that it's not just about the jets in France. There's also an order seizing some of our assets in the UK.
In Liverpool,
yeah. For people who are saying that these courts didn't have the jurisdiction, with some Isisage saying that in the papers this morning, do they have a point?
Well, so Professor Isisage is a professor of law. I'm a journalist. The only difference is that I have been speaking with lawyers and diplomats about this matter. And what I have learned is that even in terms of the evolution of the law, some things have happened that some of the the people in liberation may have not caught up with. So lawyers say that, that look, this is international law. So you're not going to find many people. As a matter of fact, those who are practicing in the country may not be abreast of the developments in international law. So lawyers who have understanding of the international law have said that there is no issue about jurisdiction. All of these things have been pleaded already. The main problem is that in that treaty, Nigeria, deliberately or not deliberately, wittingly or unwittingly, allowed a situation where a company can actually sue Nigeria. Now,
they're not doing the wrong thing by doing that. As in, the company is not doing the wrong thing by suing us. The clause exists in that agreement.
And that's the unusual
who put
thing.
This clause?
Exactly. So that's the.
We're still trying to find out who put it.
Yeah. Well, we have to, we have to ask, the people who were there if we wanted to really get to the bottom of the matter. So this went through, like I was told, it went through the Ministry of Foreign Affairs, it went through the Ministry of Industry and Trade, and it must have also gone through the Office of the Attorney General.
The Minister of Foreign Affairs says.
Well, this was in 2001.
The present Minister of Foreign Affairs in Malabo, he said.
Right.
We cannot be. This is something that was done without carrying the necessary people along, and this is why these negotiations came up with clauses such as this one that has put us in this situation. Yeah,
well, I think that Mr. Tuga shouldn't have even made that kind of a public statement, because it can be used again. I mean, it portrays us as a people as confused.
Because it's strange to me. One of the issues that and I haven't gotten an answer to this question, was litigation has been going on.
Yeah.
Over the years, who has been representing Nigeria's interests in those litigations?
Very, very good question, Kayla. And I think they have the lawyers there. But one of the things that I found out is that so there were at least 2 instances in many of the cases, all over the place, in the UK, in the US, where you have the judges and the people that are involved in the whole process complaining at least twice that the Nigerian side was not diligent. For instance, there was a time when Nigeria had I think they had 74 days to make a filing. And Nigeria did not do the filing until after it expired. Now, that kind of stuff happened twice, which tells you also that there's a bit of tardiness, tawdriness, and sloppy, work, which is very, very embarrassing.
Which is the reason why these kinds of seizures happen. Many people may not understand, but that when it feels like you're not taking us very seriously, we have to do something to make you come out.
Exactly.
Which is the reason why this has happened. But I want to go back to that timeline. 2012 is where we stopped at 2011, right? So let's see what happened afterwards. So 2011, that was where we were. Let's move on to the next year. 2012, Ogun State appointed them as the interim manager of that zone, of that zone. And then move on to the next one. Let's see what happened next. 2013, a joint venture agreement was signed, making them, that Zong Fu, the permanent manager of the zone and giving it majority shareholding in the project. And then something happened between 2013 and the next time we found out about this story. 2016. By this time, the Buhari administration was in office. You were SA Media to the vice president at the time. Okay, just so we situate that. Ogun State abruptly terminated the appointment, took actions to expel the company from Nigeria, including the harassment of his executives and revocation of immigration papers. One thing that we saw that happened in 2016 was that the Chinese government here in Nigeria, and some investigation went on, according to Mr. Ibikunle Amosun, who was governor of the place. So he says they came up with information that Zong Fu had actually lied to the Ogun State government and painted the other company as a bad entity, and they found out that it was a lie, and that basically led to them revoking their license to run that place. At that time, the Buhari administration was in office. You were SA to the vice president at the time. What happened?
Oh, well, so first of all, to do a disclaimer and say that, look, you possibly wouldn't know everything that is going on in government. So I didn't really even find out about this. Like every other person else, we're just hearing about this now.
It wasn't spoken of at all during the Buhari administration.
I don't think so. Certainly not to my knowledge. These things were so essentially at this point, this had become something that was just between the Ogun State government and the local Chinese farm. So at that point, but everything is based on the treaty, okay? So I wouldn't even say that there had to be any involvement of the federal government at that level because everything ought to be running smoothly. I think one of the problems that happened in this case was the detention of, I think, one or two of the Chinese company executives. You know, they have made the claim that, you know, they were detained, you know, for about 10 days or thereabout, you know, and then, of course, after the guy was released, you know, he left the country and then never came back. I guess that must have traumatized them. Now, former Governor Bikunle has said that, look, this was essentially a dispute between two Chinese firms. But he has also considered that he himself did not pay attention. He didn't pay diligent attention. The governor, you know, Amosun said this himself, that he didn't pay diligent attention to the agreement. But what should happen?
What should happen to all the parties involved? First of all, let's even get to the go, like you said.
Okay.
Someone has claimed culpability. The Ogun State governor said, "This happened during my time. These were the errors. We were tricked." This is what he said. That's right. Accepting blame for
his whole, you know, lack of due diligence.
Yeah. What should happen? Because it's now snowballed into something that's affected the rest of us.
Yeah.
So what should be done to the players involved at the time?
Well, you know, I don't know whether doing anything to them will remedy the situation.
It might make Nigerians feel good.
Well, and that's the point, that so we have a national embarrassment. So we are dealing with the national embarrassment where a company, a local Chinese firm is saying that, look, okay, we're gonna release, you know, one of the jets so that your president can fly. That is so, you know, so embarrassing, so shameful. Now, so that is what we are dealing with. But whether, you know, somebody has to be blamed or not, I would rather say that the process of the verification and the you know, how that treaty itself was allowed to go, because normally before you have a treaty, like I said, it will start drafting, foreign affairs will be involved, our Ministry of Justice will be involved, our Ministry of Industry will be involved, and then it will even go to the Federal Executive Council. So all of those steps were taken, yet not one person was able to say that, look, you are given the right of action, legal action, to a non-state actor, which is the business is to bring a case against, because if that wasn't there, it would have to take the Chinese government itself to go to court. Now the Chinese government would rather, you know, rather want to sort it out diplomatically.
Which is what the Foreign Affairs Minister is saying. Let's go back to that timeline to see how things started going downhill from 2017. That's where it started going downhill. Zhongshan initiated arbitration proceedings against Nigeria, claiming breach of the Bilateral Investment Treaty. That was in 2017. Things started to go downhill there. 2021, the tribunal, chaired by Lord Neuberger, former president of the UK Supreme Court, ruled that Nigeria breached its obligations under the Nigeria BIT and issuing a final award of $55.6 million in addition to an interest of $9.4 million and cost of...
And that was 2017.
2.8, this is 2021.
Okay, now this is not 2021.
Yeah, 2021. 2.8 million pounds payable by Nigeria to Zhongshan. The amount is total amount is about 70 million.
Right now.
Let's fast forward. So this was in 2021.
Right.
When this judgment was given,
right,
we had a government in power.
Yes, of course, yeah. So at this point, you know, as a matter of fact, the moment it got to arbitration and all of that, and don't forget that they had actually, they claimed they even they started in the Nigerian court, they didn't get any progress, and then they took it to arbitration, and then it went to some international courts. So at this time, the Justice Ministry in Nigeria at that time, 2021, must have gotten sufficient knowledge, and they were part of what was going on, you know. And that's why I pointed out that one of the things that I found quite, worrying is the level of sluggishness.
I mean, if we're going to throw fault lines on this, everybody that was in government as at this time, when this judgment came out, should be called to explain, because they also have something to explain.
I think so. I think that, I mean, well, my job, it's, people have specific job, so yeah, my job when I was there was to explain what the presidency was doing, especially the vice president, but yes, the Attorney General at that time, the people in the Ministry of Justice at that time, they were responsible for the Nigerian case, because it was not Ogun State that was taken to court, by the way.
Yes.
And that's the point. It was the federal government of Nigeria. So it would be good to hear from those people. Yeah, so how come you put up what was clearly a poor litigation, even in terms of the tardiness, that at least on 2 occasions, the judges did point out that Nigeria was not filing its own pleadings in good time. They were not filing it in the time allowed by the rules. That kind of thing is completely very, very poorly done. It's not good at all.
Ayo?
You, Kayla. Mr. Akande, 2 things stick out for me. But let me begin with this one. And I mean, it's rightly noted when you pointed out the fact that the Buhari government didn't get into power until 2015. And this particular issue rose again in 2016. But let's also not forget the intention of the president of the day in 2001. Nigeria was gunning for all the foreign direct investment it could lay its hands on. And so when the federal government decided to have that bilateral investment treaty with China, it was with the intention to bring in foreign direct investment. But also knowing our system, one would wonder, I mean, that it's always government in, government out. One president will come, another president will go. But the civil service is always there. There are those who were in government in that year, who are still in government now, who are aware of all of the things that have happened and have all of this information. So if the civil service is supposed to guarantee the continuum of some of these activities, what would you say is the role of the experts in the Federal Ministry of Foreign Affairs, or even in the state government at the time, until this matter, boiled over to what we have now?
Yeah, I mean, you're right. There are different levels of involvement, right from the state government, and I think for the state government, what I find that was poorly done in the state was the fact that they had to detain and harass, the Chinese executive. That seemed to have been, a part of what actually provoked this action, besides the fact that they had also lost money. We understand that those guys have paid a lot of money. They've put some structures. We've even heard from the exchange between former Governor Musu and Professor Patu Tomi, some of the things that went down. So clearly, there is responsibility for the then Ogun State government. Of course, this started under Benga Daniel and then went to Amosun, and then, of course, Prince Dapo Abiodun. So I think there are important issues along that line. But let's bring it to the federal government. Now, so yes, there are civil servants. I imagine somebody who was in service in 2001 up to now, that is almost 23 years ago. So the people that might be left now will have to be the very, very junior officers, by the way. But this is the role of institutional memory. And that's the kind of things that we have to deal with when we talk about civil service reform. What is the level of institutional memory that is being retained and maintained? Do we have a mechanism to keep all of these things going? So in the Ministry of Foreign Affairs, in the Ministry of Investment, Trade and Industry, and in the Ministry of Justice, those are the places where responsibilities, will have to be addressed as to what happened and how do we prevent this happening again going forward. I think that Otunba Daniel has actually offered, to give help, in terms of what happened in his own time. Governor Amusu has spoken. I'm sure that Prince Dapo Abiodun too, might be also speaking about this, just to explain to us what happened at the level of the state government. But the more important thing to deal with is how come Nigeria signed a bilateral investment treaty that allowed non-state actors, that is non-government, to be able, because there's a clause in that treaty that enabled a company to challenge a sovereign government. That is the unusual thing that happened in 2001. And it would be good to find out why they had to accept that. Or was it that somebody was just caught napping at the wheels?
At least as at now, the government of Ogun State had put out a statement sometime about a week ago, making moves to vacate what they call a fraudulent legal process. But then that, clause that you're talking about is what they call the investor-state dispute solution. Now, the idea of it is, as you have, may be aware of or may have been told by the lawyers, an intention by the investor to protect their foreign direct investment in the country. And it also speaks to something that you also stated, which is the fact that to a large extent, a good number of people have questions as to how we do stuff in our country. And I'm just hoping that this will be some kind of lesson for us as a people. So it's the investor-state dispute solution that is in contention here. And it is something that, some lawyers believe that this is already being contested in various other parts of the world, including the United States. So in that regard, knowing the quote-unquote desperation of Nigeria, and in this particular case, maybe some subnationals in the country, to get foreign direct investments into their states for whatever, well-intentioned, good intentions that they may have. Where do we go from here? Because what other guarantee can an investor have if they don't have this investor-state dispute solution, ISDS as they call it, to protect their investments in the country?
Well, two things, Hayo, in my view. First of all, we have to do a comparative analysis, as to whether that kind of clause that enables a company to take an action against, the government in a treaty that normally involves state to state. Now, it would be good to know how often is this done. What my whole investigation and talking to some of the experts has shown is that that is the unusual thing, that happened. It's unusual. It's unusual to have to say that, look, I will even allow companies to be able to take me to court. That's the unusual thing so far from what I've gathered. Now, the second thing is that the first one, that responsibility is entirely, in my view, for the federal government. But the state government, particularly the government of Governor Amusu, also played a very big deal in all of this, because the discontent that happened started under Governor Amusu. And I'm sure that Governor Amusu himself must be, feeling a little bit, not very good with himself, because it was the same Governor Amusu who we are told had issue with Dangote, and so we have to begin to also understand that when we get into these agreements have significance, and we can't just do whatever it is that we like or choose. Governor Amusu came out and said, yes, I didn't pay attention. Now, that's not very good. That's not very good.
I mean, one of the issues that people have brought up is that these jets were undergoing servicing in France. the Nigerian government at the time said that these jets are under diplomatic immunity, should have been protected by diplomatic communities. They need, despite what these contractors said.
Yeah, well, okay, so
has said rather, should they have been protected by diplomatic immunity?
Well, you know, the lawyers will answer that question, but I think the part of the evolution that has happened in the legal world is the fact that once a state allows you enter into the commerce balance. Once you allow yourself to enter into that world, then you are bound to follow the due process, especially when you sign a treaty yourself, giving the power to a company to sue you. You know, so you know, from what I've gathered so far, it is. I mean, and the courts, the U.S. appeal court, has said that yes, you know, they can go after your property already.
Well, we do have to wrap it up. I think there's a conversation that's going to continue.
And by the way, you know, we're going to dig deeper into this.
What's happening on inside sources?
Yeah, so this is the main discussion that we're going to be having. We're going to be listening to the expert, legal expert, and diplomatic experts to further espouse, you know, on what this really means, you know, for our country.
I mean, the Foreign Affairs Minister has said they're working on a diplomatic solution, him and the Attorney General of the Federation, but we'll be watching to see how all of this unfolds. Thank you so much, Mr. Laolu Akande, for being with us on the program.
Thank
Mr. Laolu Akande, former presidential aide and the host of Channels Television's Inside Sources. I'm going to tell you the nickname.
11:30 tomorrow.
When 11:30 tomorrow? Yeah. We have a nickname. We have a nickname for your program. I'll tell you off air, but thank you so much
All right, thank you
for being with us.
Thank you so much.
All right.